All right. Well, hello, landlords. It's good to see all of you here live. I'm happy to join you here live. It's our first YouTube Live of the month of December, and I'm excited about the questions that we've got today and the topics that we're going to cover, and particularly the topic that is at hand. The topic of today's talk is what's the best way to charge late fees. I'm going to offer some suggestions to you that I hope you find helpful, in your landlording routines, because, some of the pitfalls that landlords go through are all about collecting rent or collecting fees and making sure that they stay profitable. And yet, while these seem like the easiest things to figure out, these tend to trip especially new landlords up, and at a certain point, it becomes an exercise in frustration. I'm going to hopefully give you tips that are going to help prevent that from happening, so that not only you're collecting more of the money that's owed to you, but that you're establishing relationships with tenants that go on for a long time. For those of you who don't know, I'm Ernie Garcia, landlord attorney. I'm a licensed attorney in the state of Texas, and I practice mainly in Houston, but I take cases all over the state of Texas. And today we're going to talk about the best ways to charge late fees in a residential lease. But we open the floor for questions from all over, and so I've prepared about 10 questions already that I'm going to give you answers for after I'm done with this talk. If you've got a question you want to add, please contribute that to the chat. I see here that James has logged on. Hey, James, good to see you as always. But if you haven't submitted a question, feel free to do that through the chat. Now, you may be asking yourself, well, Ernie, I don't know how to submit a question. Well, there's a couple of ways. First, you can get it on our email list. And to do that, you're going to see a ticker along the bottom here that has our phone number. You can give us a call or send us a text or shoot us an email at this email address, and we'll be happy to put you on our mailing list. Once you're on that list, you can submit questions for our weekly YouTube Live. I'll prepare an answer for you and present it here. For everybody else, you have another option, particularly if you are a landlord in the state of Texas. You may know about our Facebook group, Texas Landlords, where we have over 8,000 members who are nonstop contributing. And among other things, I'm answering, legal questions for them. And so people will hop on and ask a quick question, maybe even of other landlords, like who's a good roofer you'd recommend in this city, or what kind of insurance do you use in this situation? And there's so many helpful tips going from knowledgeable people who've been doing landlording for a long time, or who have many more units than you do. And so you can glean from their experiences and from the years and years of routine of landlording, and that's always a help to you, especially if you're just starting out. So you can join our Facebook group, Texas Landlords, join our newsletter, or simply throw your question into the live chat. I see Alexander Valentin, whose questions I've got, because he submitted his questions ahead of time. I'm going to go ahead and answer those later today. But let's go ahead and get started with the topic at hand, which is, what's the best way to charge late fees? It's a common question that I get about, how to manage, tenants. People are sometimes hesitant to charge late fees. I've seen landlords who go years and they'll say, Ernie, this guy's probably paid me late 20 out of the last 24 months. But eventually he pays the rent. I'm just sick and tired of having to deal with the, inconsistency of his payment. Well, I'm going to give you the same advice I give that guy. And so I'm going to give you 4 tips that I think are extremely helpful that pertain to late fees, but mostly that pertain to just good property management and the kinds of things you can do to make sure that, again, you're collecting the maximum amount from your clients, but that also you're establishing a relationship that could go on long-term, that should go on long-term, so long as both of you are abiding by that lease agreement. So let's talk about the first point is, do you know what your lease says? If you know what your lease says, you're going to be able to enforce it. But it might not surprise you It should, but it might not surprise you that many landlords have no idea precisely what their lease says or exactly how it works. So that inexperience leads them to simply leave provisions in their lease, namely in this situation, the late fee, as something they just don't enforce. They know it's in there, they know about it, but they're so timid about it that they never enforce it. So it's helpful for you to know what your lease says right from the beginning. Because one of the things that I strongly recommend that all landlords do is that they have a conversation with their tenants before the lease ever begins. You want tips on how to charge late fees? I'm going to give you tips on how late fees are never going to be an issue. By you knowing the text of your lease, you're going to be able to talk to your tenants ahead of time and prepare them and say, look, if it turns out you're going to be late, I'm going to charge you X right from the beginning. And at a certain point, I'm going to cut things off and send a notice to vacate and begin the eviction process. I'm hopeful, however, that will never happen. I'm certain your lease will always be on time. So by knowing what your lease, I said lease, but knowing that your rent will always be on time, but by knowing what your lease says, you're going to, again, establish a baseline for your expectations for that tenant, and you're likelier to be able to recover, again, a maximum amount of profit from your lease, when the time comes. And you're going to know precisely what to do if, in fact, the tenant fails to comply with that lease. So, and that's what the next step is. The second point is, do you know what the law says? So I sometimes get clients who come in and they have these fantastic terms in their lease because they know what's in their lease. They drafted it. And their lease says something, for example, like, if your rent isn't paid by day, we'll just make up a day. Day 5, I'm going to charge you $150 a day until the rent is paid. And they come to me and say, Ernie, this cat hasn't paid in 100 days. They owe me $150 for 100 days. I say, well, that's interesting because that's $15,000 in late fees. I said, yep, I want to collect my $15,000 in late fees. And what's the monthly rent? Oh, it's $1,200. Okay, so they haven't paid in 100 days. It's about 3.5 months. So that's about 4 months worth of rent. That's $4,800 for a $1,200 rent. And you want to collect $15,000 in late fees? That's not legal. And so you go to the law, and I open it up and say, this is where you are limited. And different states are going to have different rules, but you need to know what the rules are in your state so that you know that your lease is properly framed. So it's not just enough to know what's in your lease. You got to know that what's in your lease is actually in line with the law. If you're unsure, go speak to a landlord tenant attorney and make sure that your lease lines up with what your state law allows. Because the same laws that allow you to charge late fees punish you for overcharging. And those punishments can be stiff depending on your state. In the state of Texas, a landlord can charge a maximum, give or take, a maximum of 12% for a late charge. Now that's 12% of the rent for that month. So if we had a $1,200 a month rent. Simple math tells me I'm maxed out at $144. I can't charge $150. Even that first assessed fee is outside of the bounds of the law, and I'm already in violation the moment I collect it. So know what your lease says, but know what the law says so you know that your lease is in line with the law. For example, in Texas, you can't start charging late fees until day 4. So day 1, the rent is due. Day 2 and 3 are a soft period where you can't charge any additional fees. The rent is technically late during this time, but you can't charge any more for it. Come day 4, you can charge up to 12%. So what I recommend to landlords is, well, if you break it up into 3% increments, you got day 1, 2, and 3, then 4, 5, 6, and 7. You got these 4 days right here where you're charging 3%, 3%, 3%, and 3%. That's a total of 12%, so that by day 7, you are maxing out. If they haven't paid everything by day 7, I recommend handing over a notice to vacate and saying, look, you owe the maximum amount of late fees, and now you got to go because you haven't paid the rent. But like I said before, if you know what your lease says and you know what the law says, that's something you can share with your tenant before the lease ever begins. And by doing this, you're likely to prevent an incident of repeated late payment or an incident of excessive late payment charges. All of that works in your favor, keeps you out of the courthouse and keeps you in profitable status. Third point, you got to act fast. Don't sit on your hands. I see a lot of landlords who, like I said at first, that guy who waited 2 years before he had enough. 2 years is way too long. 7 days. If your tenant is late, you have to be on it. You have to have a remedy. You have to have a line in the sand where you have some action point. Whether that means getting on the phone and giving them a call, or whether that means sending a text, or whether that means issuing notice, you've got to know what you're going to do, and you've got to do it fast. The longer you wait, the more you lose. The more you lose, the less likely it is you're going to be successful at landlording. So act fast and make sure to be decisive. Again, if you know by day 7 that you're going to be issuing a notice to your tenant, guess what you can do before you ever hand over those keys? You can have this conversation with your tenant and saying, I know what my lease says, I know what the law says, and here's my procedure when it comes to default. And the last one is, don't be afraid to use notices, because sending these notices is your best weapon when you're having to file an eviction in court. If you can't demonstrate to the court that you send adequate notice to your tenant, the court may not be disposed to helping you out when you want the court's help in evicting that tenant. So make sure that you've notified. Don't let 20 months go by before the first time you tell the tenant, hey, I don't like this late rent thing. Because again, you're having the conversation before the lease ever begins, and during the lease, you're reminding your tenant of what you said. Remember when I said, I know you paid on day 5, but you paid late. Thank you for paying all of your late fees, but that's still a default. Here's a notice of default. Make sure this doesn't happen again, because repeated default will likely result in an eviction. And hopefully by doing all of these things and talking about it ahead of time, you are preventing ever having to charge late fees. But if you're gonna charge late fees, know what your lease says, know what the law says, make sure you're acting fast, and always, always, always deliver a notice. By doing these things, you're gonna get better at collecting late fees, and you're going to get better at preventing the need for ever charging late fees. This always happens. I had a couple of landlords who tell me, well, Ernie, I don't mind collecting late fees. My tenants pay the late fees and late rent whenever they want. I'm fine as long as they pay both before the end of the month. What is that indicating to you, landlord? If your tenant is perfectly comfortable paying the late fees, don't ever just renew the lease based on the same amount of rent year after year after year. To me, that tenant is telling me, guy, you're just not charging me enough. I am comfortable paying not just the base rent, but on top of that, an additional 12% in the state of Texas. And so why not why not accommodate them? Bump the rent up to by 12% at the end of that year. So for example, your rent was $1,200, 12% is another $144 on top of that. The next year at lease renewal, you're bumping that rent to 1344, 1350, because apparently they are comfortable. They're used to that amount. And by meeting them there, eventually, hopefully, they'll recognize that the amount that they're paying has become a prohibitive amount. And either they'll stop paying and leave, or they'll simply stop paying late. And so by setting your clients up or your tenants up for success, you're likelier to get a better return, you're likelier to get predictable payment at predictable times, and you're likelier to maximize what you're getting out of your rental. And so I hope these tips have been helpful to you. I'm now going to go ahead and begin with the questions that have been prepared. And so if, like I said, you've got a question, I want you to feel free to, add that to, go ahead and add that to the chat, and I'll go ahead and, do my best to answer. I can't answer everything, but I'm certainly going to do my best to answer any question that you present in the chat to the best of my ability. So here is the first question that we got. Okay. If the JP constable could not serve the eviction to the tenant by hand, but posted the notice on the door, on eviction day, will the judge dismiss the case? So I'm going to presume that this is a Texas-based question, because I can't answer for the state of Illinois or the state of Wisconsin or the state of South Carolina, but I can talk about what happens in the state of Texas. And typically, no, if the constables fail to serve it, that's not a basis for dismissal. It could be a basis for delay, though. And typically what happens in the state of Texas is the court will reset the case. Well, the rule presently through the end of this calendar year is that the tenant has to get at least 6 days of prior notice. However, beginning January 1 of next year, that rule changes. And as of January 1st, it's no longer 6 days. Now they're only going to need 4 days. So it's less likely to occur in the future, but it's still a possibility. So if you find yourself in a situation where the constable simply hasn't been able to serve the tenant notice of the eviction, well, you could see yourself in a situation of delay. But it shouldn't be too much longer in the state of Texas. Again, in other states, the procedures are different. And so I'm not going to speak about procedures in another state. But Nancy had a follow-up question. So we're going to answer Nancy's second question. If the eviction is for holdover, should failure to pay rent, violation of the lease, and holding over all be checked? Now, I'm presuming what you mean here, and you submitted a little picture, but it was kind of blurry. I couldn't see it very well. But I'm presuming what you mean is on the form that the court has provided, if you're suing for holdover, should you include non-payment of rent? Well, if they didn't pay you rent, even if you rejected it in the state of Texas, you can claim non-payment of rent. Because in a holdover situation, if you do accept the rent, you make a tacit agreement with your tenant that they can stay there for another month. But that's not your intention. If you want to sue to recover possession, you have to reject the rent. But when you sue them, make a rent claim, because rent is in fact owed. And so they have the opportunity to leave without owing you any more money, but they didn't do it. So now you have to sue for eviction. I would sue to recover unpaid rent, and I would sue to recover possession. And with regard to violation of the lease, I mean, technically non-payment of rent and holdover are both lease violations if they're stated properly in your lease, and they should be. It doesn't hurt you to mention all three. So yeah, go ahead, mention all three. It's not going to harm your eviction case. So let's move on. I want to check real quick. All right, so we've got some contributions to the chat. Vishal here, rental in Texas. Whenever it rains heavily, water from adjacent property comes over to the rental, causing damage to the property. Already spent $10K and the problem still happens when it rains. What are the legal pathways to handle this? Well, it sounds like you've got a nuisance that's being caused by your neighbor. And so, assuming you don't own the adjacent property, your neighbor is causing harm to your property. And I don't know how things are laid out. I don't know how large an area this is, but you might need to hire a civil engineer to come in and maybe offer a suggestion on how to modify the terrain so that water flows in a way that is proper. I don't know if a drainage ditch has to be, dug or what, but it kind of sounds like you have a nuisance claim against your neighbor for causing harm on your property. I would seek a local real estate attorney to see about filing that claim and definitely making a demand on the neighbor. Now, if this is something that you created somehow, you opened some pathway that wasn't there before. I don't know enough of the facts, but if it's purely based on your neighbor's use of the property or maybe how they reshape the property and now it's causing you harm, it sounds like you probably need a demand letter on that neighbor. Okay. McNary Realty Group writes, "Hey, Ernie, hope you get to discuss the crazy for me Kaufman County discussion. Get to discuss the crazy, foamy Kaufman County discussion." I am a little lost. If you could kind of clear that up. If you asked a question, I certainly have answers to all the questions that I got presented early. Give me a little clarification on that, and I'll do my best. I will do my best. All right, so here we go. So question 2, this is from Greg Sanders. "Per my lease, the tenants must have carpets and flooring professionally cleaned by a licensed contractor. Tenants submitted no evidence or proof that they actually did this. Since they haven't fulfilled their obligation under the terms of the lease, can I still retain their security deposit past 30 days after move out?" Okay, well, Greg, we have a couple of things we need to address here. Again, we're talking specifically about Texas law. And so in Texas, you can only, so first and foremost, the fact that the tenant breached does not mean that you automatically get to keep 100% of any security deposit. So breach, some independent breach does not automatically cause some forfeiture of the deposit. I hear landlords say this all the time. Oh, well, they terminated the lease early without cause, and therefore they've waived their right to their deposit. Even if that's in the lease, that's not an enforceable provision. That's not how security deposits work. In order to deduct any amount from a tenant security deposit, you have to be able to prove a 100% valid basis for doing so. And it sounds like you have one, maybe. So the intent of this provision in your lease was to have the flooring and the carpets cleaned in a professional manner. So the courts aren't so concerned that they hire a professional, because individuals can do the same kind of work as a professional. So if they return the property to you in a way similar to the way they got it, i.e. you hired a professional company and they returned it to you professionally cleaned, even if they did it themselves, then a court's likely to determine that you have not actually been harmed. The fact that they didn't pay anybody to do it doesn't necessarily mean that your property was in any way injured by this process. So you got to prove that you were injured. One easy way to prove that is if you have evidence that the property wasn't cleaned at all. And so you show up and there's food and gunk in the refrigerator and the carpets are full of pet hair and there's Kool-Aid stains and all sorts of stuff that you had to get professionally cleaned yourself. Those damages are easy to prove, and because it is in excess of normal use and ordinary wear and tear, you should be able to deduct those fees that you paid from the security deposit. Again, it's not just an automatic, they didn't do it, I get to deduct. You have to have suffered some kind of economic harm in order to validly deduct from the security deposit. So I don't know what this professional cleaning costs, and I don't know from these facts exactly how much you had in a security deposit that you were holding. So it's really going to depend on how much you were holding and what fair amount can you deduct based on whether or not they harmed your property. Greg, I hope that answers your question. So, let's go back over here. All right, we got a few more questions. Forney, Texas. So, hey, Ernie. Forney, Texas. Okay. Still not exactly sure, but we'll get to the bottom of this, I promise. So let's go on with Vishal Bonsal page. Neighbor is storing their junk stuff on our side of the property. Oh, that already sounds like trespass. And not removing it after verbal request. Well, that sounds problematic. What should be the next step is blocking contractor to do yard work. Well, let me give you a simple remedy. If you parked stuff on my property and just left it there, I can do whatever I want with that property. You're not allowed to dump your garbage on my property. So I can get it and I can throw it in the dumpster today. I don't need to ask your permission. I don't need to make a demand. The moment your stuff trespassed onto my property, you lost title to it, especially if you put it there without any authorization. So that's one thing. The other thing you can do is you can send a notice to your tenant, or notice to the neighbor, and then threaten to sue them if they don't do it. I don't know what it is that's doing it. You call it junk, but if it's heavy and hard to move or dangerous to touch, you might want to sue them in court. And you might even need to go and get an injunction from the court to prevent them from ever doing this again. But if it's on your property and you can pick it up and dump it in the trash, I'd do that in a heartbeat. So that's one easy one. Otherwise, you could utilize the courts, but that's much more expensive and takes a lot longer. All right, Scott M, 4977. Hi, Ernie. Have a tenant who isn't paying the electric bill. Lease says tenant is responsible for charges over $150 per month. I've sent a copy of the bill, sent her a charge via portal, ignored. Evict time? Maybe. So first, I don't exactly know what your lease says. I'm going to take it for granted that it says what you say it says. Secondly, do you have an application of funds clause? An application of funds clause says the next payment I receive from you, guess what? It's the beginning of the month. It's probably a rent payment. If you're talking about fees from last month, an application of funds clause says I can take your payment and apply it to old stuff first. They owe you late fees. They owe you utility bills. They owe you unfinished deposits. Bloop, 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 bloop. You can apply the payment there and say, guess what? Notice of default, because you now have a rent balance. I applied your payment first to last month's charges, or whatever charges are on the rent ledger, the oldest ones first. And now you don't have enough to cover the entire month of rent. If you don't pay the rest of the rent, you will be in default. I'll give you 3 days, or I'll give you 5 days. And by issuing this notice and letting them know that your application of funds clause allows you to do this, you set yourself up for a much cleaner eviction filing. Because now you either have A, their refusal to abide by the lease, so you got lease violations, but B, even stronger, is a claim for non-payment of rent. And so, I would definitely go through that motion and issue that notice. Some courts are going to require that, but a few will. And so because of that, I always recommend in these situations reminding the tenant, hey, look, this clause is here for a reason. I'm exercising it. I'm giving you a reasonable amount of time. If you don't want to do it, that's fine, but you're going to have to go. And so by making it very clear to your tenant with adequate notice, you're likelier to get your eviction. Okay, get lobbyster. Okay. To maintain privacy and anonymity, is it acceptable for a self-managing landlord to sign and execute a lease using their business name, registered as a DBA, even in the fields that ask for the landlord or authorized representative's name and signature? Yes. Now, let me tell you about a DBA. A DBA is essentially just like a nickname. So my actual name is Ernesto Garcia, but very few people pronounce it properly, and I don't like my name mispronounced, so I prefer you call me Ernie. So by signing anything Ernie Garcia, I'm not lying to the world. That is me, but it's not my birth name, right? And so using a DBA is like that. It's you, just a different you in a different shirt. But if you register an entity, it's important to know, well, who actually owns the property and who's managing the property. Because depending on what your lease says, you can have a landlord that is the manager of the property, even though that landlord doesn't own the property. What you absolutely need to do is be consistent, though. The landlord is the one who signs the lease. And if you're having a property manager or a property management company sign that lease, you might be forced in certain courts to produce a property management agreement that says something to the following effects. I have permission to sue tenants for eviction and recover judgments in my name, even though I'm not the owner, but I have the owner's permission, and here is my property management agreement. I've seen this come up very rarely, but I have seen it come up. So if you're going to do things in that way, where you're a property manager that signs leases and evicts in your own name, even though you are not the owner, I would keep a property management agreement on hand. The other is, I transfer title to this property into the name of my holding company. And so now the holding company is the owner. It is some name different than my own. It's a registered entity with the state of Texas, Garcia Properties LLC, for example, and I sign it in the name, Garcia Properties LLC, Ernie Garcia member, or Ernie Garcia owner, Ernie Garcia CEO, whatever. And so in that way, you can distinguish yourself. Now, it's pretty obvious that Garcia Properties is something that I own. So maybe you're going to use a name that's a little more ambiguous. And so you might have 123 Elm Street LLC, an entity specific to that address. And it's the company that owns it. And I'm just here. I'm the dude who manages it. But the actual owner is 123 Elm Street LLC. And so for purposes of anonymity, yes, you can definitely, use different parties, but it's important that you have distinct roles and specified permissions, because some courts are going to ask you for it. If that's too complicated for you, I wouldn't mess around with it. If you need more help, book a consultation. That's going to be your best bet. Scott M, 4977. Tenant has stored items in an unauthorized room on property, asked nicely to remove and still there, talked on the phone. She agreed to move, still there. Notice and evict time? Possibly. I like a 3 strikes and you're out approach. And typically what I do in a situation like this is I'll tell a landlord, look, give precise deadlines. Say, look, we've talked about this before. I'm giving you written notice. You've got 3 days to remove these items. They violate the lease. And even point out the section of the lease that's being violated, and then send a notice. And then show up on day 5 or 6 or 7, sometime after the deadline, say, look, I sent this on purpose. It hasn't happened. I'm going to have to give you another notice of default and notice that I'm coming to make sure that you've complied. And you do it again. And after 3 times, they haven't done it. That's when I would say, all right, we've gone through this at least 3 times. Here's your final notice, but this is a notice to vacate. At that point, even if they've paid the rent, I think if their violation is egregious enough, and if they're a hoarder or they're causing potentially a fire hazard, or they're allowing pests, or kind of a haven for pests. All of that's bad, and it has potentially a very negative effect on your property, or it could affect your insurance. So you want to make sure you're getting rid of those. But 3 strikes and then they're out. If you've given them multiple opportunities and fail, they've done it 3 times, issue that notice to vacate. McNary Realty Group, and force evictions of anyone in home is I guess you mean if anyone at home is arrested. Maybe, yes, that's definitely a possibility. Depending on how they're arrested, or what they're arrested for. Not everything is ascribable to the tenant, particularly in a domestic violence sort of thing. So one tenant might have to go, and the other tenant in a domestic violence situation might actually have an out to early terminate the lease. So every situation is a little bit different. Scott 4977 writes, would like to know the same thing. Can an LLC be named on a lease and have an agent manager sign as rep? Yes, I think I covered that. If you have more questions, I'll add to it. But yes, have the application of funds for sure. Very good. Scott adds, I learned it from you and started putting it into leases. Great. I am always glad to hear that. Let's see. In my opinion, 777, Ernesto Garcia. I am thinking of renting a guest unit, but the water is on the same line as the front house. What's the best way to handle this? This seems tricky. Thank you. You're right. It is tricky. And so you can do this in one of 2 ways. Water can end up being a problem, but billing for water can end up being a bigger problem. And so one thing that sometimes apartment complexes do is they charge by the square foot. So let's say you live in the front house, it's a 2,000 square foot place, and they're in the back place, and it's, an 800 square foot place. So 2,000 square feet is certainly larger than 800 square feet, but you can figure out the math to determine the proportion of the water that is likely used by the front house and the proportion of the water used by the back unit based on the square footage. And so if the lease portions out, hey, every month I'm going to give you notice of what the water bill was, your share is proportionally set based on your 800 square feet compared to my 200 square feet. And I guess I could have made the math a little easier and said 200 and 500 because that's 20% versus 80% of the total. So let's assume those numbers. A 2,000 square foot home and a 500 square foot unit, and so that 500 represents 20% of the total. So it's 20% of the water bill. And so that's easy to prove in the event that you're ever challenged. And because it's in the agreement that way, it is usually pretty enforceable. The other is to just charge a flat fee for water. And if you can come up with a reasonable amount that's, again, agreed to in the lease, then that's something you can do. You could always also just increase the rent to that amount. I wouldn't charge a separate utility fee. If you're going to go flat, you may as well just roll it into the rent, call it a water included rent fee, and just call it rent. I wouldn't bill it separately because it's harder to enforce. And so that's one way. The most expensive way is to have another meter installed and have a line run directly to that unit. But yeah, that's it's costly. All right. James, unfortunately, I have this problem with water as well. Water's a major expense for me. I tried to build it into the rent. Yeah, so that's one solution. It's not perfect, but it's an easy one to enforce. So let's jump back to the prepared questions. Here was an interesting one. Okay, so Jessica Van Cloyd writes, does SCRA protection for early lease termination apply for military retirement if the effective date of the retirement on the orders precedes the date the tenant gives notice of intent to vacate? So This is kind of a complicated question with a lot of moving parts. But essentially, if an active duty service member is called out to duty or they're being moved to a different area and can no longer fulfill their lease, the law says that once they show you those orders and give you notice of their intent to leave, their lease terminates based on those orders and that notice. And so they can terminate their lease and leave if they're forced to move. But this is a different situation. I don't think it would apply here because the guy is retiring. So he's not being shipped out. In fact, he's being left alone. And so if he's retiring from military service and he plans to, and his stint with the military ends before the end of that notice, I don't even think he can early terminate at that point because it just doesn't comply with the early termination rule that's found in the Texas Property Code. So I might need to know a few additional bits of information for this particular case, but it doesn't feel like the provision in the Property Code that otherwise allows for early termination would apply in this case because he's just not leaving because of some kind of deployment or some kind of forced move that's being imposed by the military. It just doesn't seem to apply here. Okay, so let's go on to the next one. Question 4. We have a wood-burning fireplace in our rental property. Should we add a clause in the lease stating the tenant's responsibility versus the landlord's regarding the cleaning, maintenance, repair, or is this already included in the lease terms of a standard TAR lease? Okay, so Vanessa, I want to mention this because it doesn't seem like a big deal, but it's always a big deal to me. I know what you mean when you say TAR lease. That's the Texas Association of Realtors lease. But there are actually various versions of it. And so depending how old your lease is, and some people are using a really old version because I see them all the time. I don't ever consider a standard copy of this lease just when somebody tells me, oh, it's the standard one. Well, because I've seen so many variations, I tend to disbelieve that. But because of that, I would also say I don't usually see specific to wood burning fireplaces and specific requirements regarding the maintenance and cleaning of them. There are general provisions in the lease that do require the tenant to maintain a clean and tidy environment. Maintenance and repair, though, again, I don't know precisely what your lease says, but most Texas Association of Realtors leases say that the tenant isn't even allowed to make repairs. The tenant is technically disallowed from altering the premises in any way. They're to make repair requests to you, the landlord, and then if the thing broke through normal use or normal wear and tear, then you have an obligation to cover those costs. You can't charge that to the tenant. But if it broke through their negligence or through their misuse, then yes, you could potentially charge them for replacement or repair. The thing that I would suggest is if you've got anything that's particular to a given property that isn't precisely mentioned in the lease, or maybe it's just not precise enough for you, you just throw that in your house rules. I always encourage landlords to have house rules for their property because you can designate very specific things. Maybe there's a swimming pool. Maybe there's a tool shed in the back. Maybe the attic is off limits 100%. You want these things explicitly stated in your house rules, which is an addendum to your lease. So this is where you can take a standard lease and modify it specific to your property. Maybe you have a water softener or you have a filtration system. Maybe you have I don't know, very particular rose bushes, and they are not to be touched by the tenant. Only you handle those rose bushes because they're so special to you. Add that kind of stuff in your house rules, and you're going to save yourself a lot of headaches because, yes, there are general provisions in the lease, but if you have something that you specifically want addressed in a very precise way, put it in the house rules. That's always your best bet. So, all right, we are up to question 5. One of my clients says her landlord, so this is a tenant perspective question. One of my clients says that her landlord went into the home yesterday without notice and told her he's getting the constable to kick her out. Isn't there a procedure for this? The procedure to do this is through a writ of possession, but it doesn't mean that what the landlord has done is necessarily outside of that procedure. Now, I don't know enough about the facts here to know whether or not the landlord violated the lease, because I don't know what their lease says. I don't even know if they have a written lease. But yeah, if the landlord has already gone through the procedure of an eviction, then yeah, that step is a writ of possession. Has it happened here? Couldn't tell you. I just don't know enough about the interaction. But if nothing has happened, none of the eviction procedures have been followed, is it possible for a landlord to simply come in and tell someone who's in their property, I'm going to have the constables kick you out? Well, you use the term landlord to imply that they have a landlord-tenant relationship. But if what you mean is the owner came in to kick out a squatter, that's different. In Texas, you don't need to go through the eviction procedures anymore that used to be in place in a squatting situation. Now, I want to caution all of you because sometimes we have a misunderstanding of what a squatter is. So if ever you find yourself in a position and you're thinking, I'm going to use that new squatter law for the state of Texas, and you run to the constable and you say, I swear that all of these provisions are true in this form that you have to sign and swear to, and you turn out to be wrong, you can get hit with some pretty hefty civil fines. So before you dive head first, come see me. I've also got content on my channel that I'm going to talk about a little more later, where you can watch and get a better idea as to whether or not these individuals satisfy the definition of squatter. Just because you call them a squatter doesn't necessarily mean they're squatting. So be careful with that. Okay, let's check something else over here. Okay, so in my opinion, 777 writes, there is a tenant currently in the front house. They've lived there for over a year and agreed to these terms at the lease agreement signing. I was thinking of leasing the back, but are they moved in? They started being strange about it. Oh, but after they moved in, they started being strange about it. I offered $75 a month, but I like your solution. I appreciate it, Ernie. Well, you're very welcome. I hope that ends up working out. You want to find a solution that's both enforceable but also reasonable, because that's always gonna fly by with the courts. Get Lobbyster says, thank you so much for your insights. You're very welcome. Scott M4977, Ernie, not a question, but a thank you for the continued videos and landlord rights info. It seems every year it's harder and harder to be a landlord and provide service to tenants. Well, you're welcome. I appreciate that. That's very nice of you to say, Scott. In my opinion, 777, Ernie, I also want to thank you. I love it. I accept that thanks. for helping us greenies. I used your advice last week and tenants straightened out. Awesome. The landlord-tenant relationship was not hurt, but now they understand what to expect. That's great. And again, so much of what I talk about here is preventive medicine. You know, if you can do these things ahead of schedule, you may never have to deal with the really big headaches that we deal with on a day-to-day. We tend to intervene when there's trouble, but if I can help a landlord prevent trouble from ever happening, even better. Jessica Van Cloyd. Hey, okay. To clarify, I believe retirement has been considered a PCS in relation to the SCRA rights since 2019. If you're asking me if I think this is a situation where it would apply, I might need to know a few more facts. It just, when I looked in terms of termination of the lease, I just didn't see it line up with the language in the statute and what was going on. And so maybe I'm missing a few facts. Jessica, if there's more that I can help with, I'm happy to do it. But based on what I read in the code and what I read from the facts, that's as good an answer as I can come up with. So, all right. Okay. Let's see what we got here. Sorry, I'm a little off the beaten path. No. All right. Here we go. Question from Robin Reeves. What are some often forgotten lease elements that should be included? This is a pretty open-ended question. I'm only going to talk about three main things, but it's a great question, Robin. And the reason it's difficult to answer is because not everybody leaves off the same things, but I'm going to target some of the things that even really great leases are sometimes lacking in. So the first is, so many people may have a notice provision in their lease and have blanks in that notice provision. I strongly encourage landlords, always put in as many avenues for contact in your notice provision as you possibly can. If you've got two tenants and each of those tenants has a work address and a private email address, please use both work email and private email if you can. If they've got them, use them. Because the last thing you want is for a tenant to claim, I never got that notice from you. But if you've got a work email, a personal email, you've got a phone number that allows for text as authorized in your notice provision, you've got some kind of app that you guys agree is usable, maybe WhatsApp or something. Maybe you have a tenant portal and you can communicate through that tenant portal and you require all of your tenants to register through that tenant portal. Now for just one tenant, you've got 5 mechanisms along with regular and certified mail. That's 7, and you can hand deliver it and you can post it. Now you've got 9 methods of delivery. And, you know, once you've got that many options, it's hard for you to get notice wrong. But if you don't have any of those because you left it completely blank, you limit yourself and kind of hamstring yourself. And that's never a good look. So, you know, what do I recommend? You know, set yourself up for success. That's always the best way to do things. And so, and you know, the notice section is one of those. So what else? So in, you know, a lot of leases, we have the occupants are sometimes not thought of. You always got to think of everybody who's going to be on the property. So it's not just enough to have the main tenant sign and disclose themselves and then sign on the dotted line, agreeing to all the terms. Because if you've got one person who's signing, but 6 people who are going to live there who are those other 5 people? And are they interchangeable? They shouldn't be. So what I always recommend is all of the adults should sign the lease. Any able-bodied adult should be responsible for that lease. Then I always get asked, well, what about adult children? Well, it depends. I mean, if they're college students or high school students, still probably not. But if they are working, if they have a vehicle, then yeah, probably so. And so make sure that you've added, all of the able-bodied adults, because you want them as, potential payers and obligees of, you want them to be obligated under the terms of the lease. And then the occupants, you want to know who they are, and you also want to know their ages. So for example, you've got mom and dad, they signed the lease, and they've got 3 kids, ages 12, 9, and 6. And the reason you don't need to know everything about them, but you would like to know a first name, and then in parentheses in the occupant section of your lease, their ages. This is wildly important because if you later go and check and it turns out, well, I don't remember a 75-year-old lady being among the listed tenants or occupants. And by having this information, you can always detect when an unauthorized occupant is living there. But if you leave it blank, and you knew that other people were going to be living there, this is where they sneak in the boyfriend or they sneak in the girlfriend, or someone signs the lease, but they never occupy. They give you the old switcherooski, and now you've got some deadbeats who are living in the house, treating the house like garbage. You can't even sue them because their names aren't even featured in your lease. So number 1 is the notice provision. Number 2 is the occupants provision. And number 3 is that house rules that I mentioned before. If you want your house cared for in a very specific way, you have to specify what you want. One other thing that landlords leave off is their ability to charge for their work if they go out and conduct a repair. Because generally speaking, courts say, wait, you did all this work? You can't recover for it. You didn't pay anybody to do it. But if in the lease, you and your tenant agree that your labor is worth X, $35 an hour or $50 an hour, or you can charge a travel fee for, having to go out there and, deliver a notice or, conduct a repair or, follow through on something that they were supposed to do, maybe mow the grass because you're getting letters from the HOA. So all of these things you can write into your house rules as fees that you can charge for services that you have to render. So, these are just a few of the things that often get neglected by landlords, but that shouldn't. Your notice, the occupants, and then your specific rules for how you want your property cared for. All these things should always be included. And there's others, for sure there's others, but these are the 3 that I often talk to landlords about, and some of them listen, some of them don't. So, all right. Let's move on. Hillary Tran writes, if the tenant found a gas leak during the holidays and can't make a repair soon, what should the landlord do to handle this situation? Will the landlord cover tenant accommodation until everything is fixed? Well, I'm a little bit confused about exactly what's going on here. So I'm going to assume a couple of things first. First, I'm going to assume that this gas leak is a pretty big problem because just the sound of it sounds pretty big. And so does this amount to a problem or a defect that materially affects the health and safety of an ordinary tenant? My guess is probably. And so I don't know what you mean by saying and can't make a repair soon. For emergencies, you don't get leeway. You got to act, and you got to act fast. So if this is genuinely an emergency situation, then you got to take care of it like now. And so I wouldn't delay if there's a genuine emergency there. I would act quickly to get this taken care of. But let's say it's not something that affects health and safety, but the tenant says, I'm not living in there. Well, then no, you don't have to pay for any other accommodations. But if it does affect the health and safety of an ordinary tenant, and the tenant says, listen, I'm not living in there, well, there are provisions probably in your lease and definitely in the property code that allow you to simply terminate the lease because you've got a situation where the property has been rendered uninhabitable. And so if that's actually the case, then no, you don't have to keep the tenants there, and you certainly don't have to pay to accommodate them elsewhere. But I don't know if that's the case here. Whether the house is genuinely uninhabitable or not is a fact issue that needs to be, sorted out. But if that is the case, then I would definitely either A, move to terminate that lease, declare it uninhabitable, and then B, do whatever it takes to fix it, because that's going to continue to be a problem. So, again, you don't have to accommodate. Here's a common one. So let's say there's a hurricane and it just takes off the roof to the entire house. You don't have to put your tenants up in a hotel because they don't have a roof. You could that day say, sorry, this is a casualty event. And 92.054 of the Texas Property Code says, I can just terminate your lease right now. There's nothing I did to cause this. It's one of those things that just happened. If that's the case with this gas leak, it happened through no fault of your own, then yeah, you call this a casualty event. It's some freak accident that renders the entire unit uninhabitable. Yeah, you can terminate the lease and essentially have the tenants removed. But I don't know, most gas leaks are pretty fixable. If you're saying, I just don't have time to get around it, that sounds like negligence. And it sounds like you may be opening the door here for a liability claim. In fact, it may be that you will have to pay for accommodations if you simply can't get around to it for whatever reason. And this doesn't sound like something, unless the tenants caused it, it doesn't really sound like something you can just transfer over to the tenant. So I know it was a long kind of rambling question, but I didn't know enough about the facts to I think really give a good answer. So I hope that helps. Okay, well, Jessica says, thank you. Jessica, you are very welcome. Scott continues, I hear conflicting info about delivery of notices. Does it have to be handed to the tenant in person, i.e. 3 days to pay or quit, eviction notice, certified mail? What does the law require? So, Scott, that's going to depend where you are. If you're in Texas, right now the law is in the process of changing. Come January 1st of 2026, the law for notices will change. As of right now, sometimes you got to give 3-day notice, sometimes you got to give 10-day notice, sometimes you got to give 30-day notice. I'm not going to get into the particulars of all of that, but all of that kind of settles out come January 1st. As far as, how you deliver it, the law right now says you can deliver by mail, regular, certified, or both. We do both. And you can deliver it in person, but you got to put it in the hand of the tenant or in the hand of an occupant that you can prove is 16 years of age or older. That's another reason to add their ages in parentheses in the lease. Or you can open the front door and affix it to the main end on the inside of the main entry door, shut the door, lock it, and leave. There is a rare situation where you can post it on the outside, but that's so easy to get wrong. The good news is that a lot of these notice provisions are softening, and I'm going to talk about this a little bit later, but I've already put out content where I talk about legislative updates for the state of Texas. So for those of you who have property in Texas, all that's getting better. And again, I'm going to be delivering even more content during the month of December and the month of January about those changes, because they do make notice provisions so much easier. If you go and look on my page, I've got information about that, which I am going to talk about in the very last posted question. So, Ernie, do you know a website for problem solving or classes for landlords? There are so many laws and little help to prevent future problems. This would be great for support. This is, in my opinion, 777. Well, yeah, I mean, I teach these classes all the time. And so if you're looking for live events, I strongly recommend, if you're not part of Texas Landlords, you go check that out. If you don't have property in Texas, then look for something locally. Anything outside of Texas, of course, I can't be much help to you because I'm not licensed to practice law anywhere outside of the state. But if you are a Texas landlord, I recommend joining that Facebook group. There are real estate groups all over the state that meet all the time and have these kinds of discussions. The content on my YouTube channel, it's free and open to the public. But yes, there are classes, there are books, there are lots of avenues for learning. Okay, in my opinion, this question tags Hillary Tran. What if the AC unit needs parts and won't arrive for a couple of days? Does the landlord pay for their stay at a hotel? Maybe you answer, thank you again. No, the landlord is not liable, particularly for AC, but a good landlord might install a window unit or put in a portable unit it's a good customer service sort of thing, but it's not a requirement under the law, and it's not usually a requirement in most leases. So no, the landlord does not have these duties to provide, these things. If there's a repair through no fault of the landlord, then all the landlord has to do is act with diligence to address that. Even if it affects the health and safety of an ordinary tenant, the law allows the landlord to take a reasonable amount of time to complete that repair, and the full rent continues to be owed. So no, it's not something that the landlord is required to do. Okay, so let's jump back in with our prepared questions. We're at number 8. Ooh, we got a long one. So Ilda Kokmik writes, we filed an eviction for non-payment. The tenant has not paid rent since October and has repeatedly made promises, excuses, and claimed that a charity organization would pay for her. The owner no longer wants to continue the tenancy, which seems obvious with the eviction filing, but I digress. If the tenant pays the full balance before the court date, can the landlord still proceed to recover possession based on the notice to vacate and the owner's decision to end the tenancy? Well, I don't know if that's what the owner wants, because what's implied by accepting someone's full rent balance? And before we continue, situations like these fail because they are not clear. If a tenant pays all the rent they owe, they probably believe, I get to stay. And if you mislead a tenant and take money, but then say, oh, by the way, you got to go anyway, you could set yourself up for punishment from that same court, not help. So what agreement did you write with that tenant? In exchange for money, we'll agree to do this. Unless it's clear that the tenant is getting nothing out of this payment, but they're paying it anyway, perhaps because you agreed to non-suit the eviction, or maybe that's what they thought you were going to do. Without having something in writing, you're likely going to shoot yourself in the foot, and most judges are just going to deny your claim. It doesn't matter that you sent a notice to vacate, because guess what you did afterward? You acted in a way that seems to contradict that notice. And it doesn't matter that you desire to end the tenancy. You act in a way by accepting rent that seems to contradict that desire. Would full payment affect the landlord's ability to obtain possession? What do you recommend? I think it would. I think most courts are going to deny your eviction. And even if they don't, the tenant could file an appeal. And on the next level, the county court could deny the eviction. Because it seems like your default was cured. So what would you do? I would enter into an agreement in writing, like I described, with that tenant that explains, what the intention of both parties happens to be. And if you can't get that down in writing, then, or if they suddenly say, well, I don't think that, I don't think this is fair. Well, that's the argument you are going to get at court when this all blows up in your face. So make sure that if you are going to accept money, that they understand what their money is purchasing. If you still expect them to leave and they have to sign a document that says, I'm going to pay this money, but I got to leave anyway, or I'm going to get evicted, it's very unlikely they're going to pay that money. But if you take that money under false pretenses, it's pretty likely you're going to get punished for that. So I never recommend doing that. It's just not a good idea. So, all right. So let's see what we got here. Okay. This. This, okay. Oh. Let's see. Okay. Tiger Harris writes, in 2026, are landlords going to be able to collect partial payments after the 3-day notice and up until the eviction hearing date, as long as no future rent is collected? Additionally, she writes, will a bankruptcy stop an eviction? So to answer question one, it's similar to Ilda's situation where a landlord is taking some amount of money. I think that always confuses the facts, and unless there's something in writing, and these are deals that we write all the time for landlords. And so if we're trying to work something out, and maybe we break up 2 or 3 payments within a certain time frame, but we're always very clear, look, if you can make these payments, great, we'll dismiss the case against you. But if you can't, you're signing an agreed judgment that says your failure to adhere to any one of these provisions means we automatically win the case. And so by being explicit in our agreement, which we also file with the court, by being explicit with our agreement, we are able to sometimes recover money for our landlord, but unless it is explicitly stated, and unless the tenant's actually getting something for their money, it's unlikely they're going to sign it. And so I wouldn't just accept the money without something in writing proving that there was, in fact, an agreement. Okay. Da-da-da. Give me 1 second. I got very last question here. All right. So Alexander Valentin, you've waited a long time for this. Here we go. All right. So he says there are several new Texas landlord laws, and I want to point out that among other things, I've got a video, and I will have more about the first 2 provisions that he mentions here. And so I want to show you what he wrote. And I apologize for how long it's taken me. Here we go. So he writes, there are several new Texas landlord-tenant laws taking effect from the 2025 legislative session, and many landlords are still unclear about what changes will impact them. Would you be willing to provide a short explanation or overview for Texas landlords covering the key updates for the new year, especially things like SB 38 and SB 1333? Well, I'm going to do you one better. I've already done a video on this very topic. Give me a second and I'll show you what it looks like. So if you look, I released this video on September 1st. I'm sorry, September 1st of this year. And let me see if I get a picture of it. Here's the actual video. Here's what it looks like. So if you go to my collection of videos, I released a video and I go extensive through both SB 38 and SB 1333 are two provisions in the code that talk about different areas of the law, but namely it addresses eviction and how to get rid of squatters, for one. So 1333 talks about the procedures for getting rid of squatters. So it made changes to the Texas Penal Code, and it made changes to a new section in the Texas Property Code, Section 24B. And so I go in and I explain the procedures in the law and how the law has changed. Again, I'm going to do additional content again over the next month or two. Just kind of fleshing out a little bit more about this, particularly as we begin to use these rules in our own practice. And SB 38 has to do with eviction procedures that have changed. Mostly, it's changed sections of Chapter 24. There's a few changes in Section 92 of the Property Code. But so these other House bills and stuff, I would say that there are some changes, but the majority of what's going to affect landlords is going to be in this video and the future videos that I provide. So let me give you a few key takeaways from these changes. So first, yes, notice provisions and the way that notice is delivered is going to be deeply impacted. And so in Texas, if your lease allows you to transmit notices through email, that's going to be the easiest way to send a notice to vacate. It's true that in other states you already can do this, but it was not true in the state of Texas, and it will not be true until January of next year. So if you're in January of 2026 or later, you now have the right in the state of Texas to send a notice to vacate by email. In fact, that procedure that I described earlier, where you open the door and put it on the inside of the main entry door, that ruined so many evictions for landlords because they didn't do it correctly. Maybe they put it on the kitchen table or they put it in the door jamb. Now, all the law requires, if you are going to personally deliver it and post it, just to leave it in a conspicuous place. And so the rules have relaxed in such a way that I think landlords are going to get more notice. They're going to have fewer problems, that is, with their notice provisions than they have had in the past. So notice issues have been fixed. The other thing is the legislature went through painstaking changes in the rules to speed up the process. It is now going to be that delivery of these citations is going to be faster. Lawsuits for eviction in the state of Texas are going to be limited to 21 days. Procedures that also speed up the process have to do with, how quickly a landlord can access the funds that are paid into the registry during an eviction appeal, or the rights to, obtain a writ of possession when a tenant stops paying into the court registry for a writ of possession. On an appeal. All these things were added to the code, and I got to tell you, most landlords don't know these rules. but I always have, and they were somewhat inefficient. Now it seems that the legislature has taken things up a notch, and for those of us who know and understand these rules, we're going to know how to operate them even better, more efficiently, more effectively, and much faster for landlords to recover possession. The final one could mean monumental changes. It has to do with a provision that's pretty new in the justice courts. It's a procedure called a motion for summary disposition. And this motion allows a court to sign an eviction judgment without trial, so long as the petition itself includes a motion for summary judgment and sworn facts that establish usually non-payment of rent over a given period and notice that was properly delivered. So long as the tenant cannot answer in a written form with controverting data, the landlord can get an eviction after 10 days of filing. And so once the petition is served and the tenant has an opportunity to submit their response within 4 days, the court can sign an order granting the eviction without even having to go to trial. This, I think, could have a profound effect, but I'm going to step back and I'm going to wait and see how courts handle these new little goodies. I'm telling landlords, you can probably expect about a 6-month period where the courts are kind of feeling out these new rules, and landlords and property managers and landlord attorneys are kind of figuring out how the courts are responding. Because remember, in any given county, you could have multiple justices of the peace operating at varying degrees of compliance with the black letter law in the property code, and we have no control over that. Hopefully, the rules that the legislature have set out are going to help to even out the uniformity of the law, but time will only tell. And so my suggestion is kind of let's see what happens over the next 6 months. I'm hopeful that things are going to get much better, and I will keep you guys posted. Oh, let's see what else we got here. Oh, yes, Tiger Harris, you asked, will the bankruptcy stop an eviction? Yeah, it'll stop it dead in its tracks. The key is agreed judgment. Yes, I agree. What about bankruptcy? It's a poison pill. Now, it doesn't stop everything forever. There is a way to lift the stay, and if it's a fraudulent bankruptcy and the court dismisses it, you're back in action in the eviction court. But yes, a bankruptcy can stop these things and just really add months of delay. It's sad. Jarrett Moore, 3858. I'm just tuning in, but I put in my lease that any late fees will come out of any payment first. Good. That sounds like the makings of a pretty good application of funds clause, which definitely in the state of Texas is perfectly legal. It's legal in most states. I can't speak for every state. Make sure you know whether your state allows such a clause. But yes, by having your tenant agree that any payment can apply first to non-rent debt obligations is a good way to recover as much right at the beginning of the month. And then if it's not enough to cover both the old debt and the new rent that's owed at the beginning of that month, issue a notice of default and seek to recover as much as you can. Guys, I don't know how many of you stuck around for this one. It's been a long live stream. Let's see. In my opinion, thank you, but not in Texas. Well, I hope wherever you are, things are going well for you. And if there's any advice that I can give in a general nature that is, kind of applicable in general, I hope that helps you. I hope, this helps everybody, particularly those of you who stuck around all the way to the end. For anyone who came in late, you are free to watch the replay. Plenty of people do that. James, I see you. Have a great week. I hope all of you guys have a great week. And until next time, guys,